Good afternoon to everyone, and we promised a 2 p.m. sharp start, and I will say this without more, that if there's one thing that most of us, certainly I, would have learned from Mr. Patterson over time, is that he is on time. And, and today we promise to do no less than to start on time. So even if we're a few seconds late, forgive it. It has nothing to do with Mr. Patterson, why we would be a few seconds late. But we thank you, of course, for having been here. And as we're awaiting well, I know the principal will be giving remarks in a minute, and he will be here on time for that as well. But today, I want us to, I now officially call the program to order, and I want to give a brief overview of what it is, and in fact, how the program came to being in the first instance. And this was one of those interesting ones where we have been having a number of reasoning sessions in the faculty for a while. And I am Christopher Malcolm, in case I didn't introduce myself initially, I didn't. And you're here in the Faculty of Law at the University of the West Indies. The principal will appropriately give his own welcome to you, to the University of the West Indies, and more particularly in this instance, I speak from the Faculty of Law. But the program today is one in a continuing series of reasonings that we're having with a view to greater public involvement in matters of national importance. But this one is special for a particular reason. This was one where, and I'm sure Mr. Patterson will forgive me for saying how it came about, but he literally called to say, there is a program I want you to organize, and I want us to do it in a context where I will make myself open to public discussion and for the media and other persons to ask whatever questions they may have about what I'm about, about the things I speak about. And he did so in circumstances where, and if you look at the overview that is at the back of your programs, and for those of you who do not have it, there's a Scan Me that was available, and that entire program is actually available. If you were to scan it, it's there. But it sets out the context and a brief overview of what the program is supposed to be. But it is a situation where Mr. Patterson had indicated that there has been ongoing conversation about our Constitution. And as we speak about it, what it is, what it means, and what it does not, one of the things that I suppose struck him, and certainly struck me as well, is the fact that we know very little about how the Constitution came into being. We know very little, most of us, about the context that led to us having what we have, and in fact, what informs some of the particular provisions that are included in our Constitution. And that is one of the things that Mr. Patterson felt he needed to speak to us about. And the program today is specifically organized with that in mind, so we can have a better understanding of the Constitution, so we can get to that critical research question of why. Why is it the way it is? Why is it that we have particular provisions included the way they are? Why is it in the context of when it was established that we have what may appear now to be some elements of it that persons may find interesting, to say the least, but at least we can get a better understanding of that, and also have somebody who was there from the outset speaking particularly about it. I am ad-libbing because I'm awaiting the principal who just came in. But I say that to say, we're not ready for you yet, principal. You can sit a minute. But I say all of that to say that we have a very special program on offer today. I certainly will not steal the thunder of Mr. Patterson for anything at all that will be done. But let me also go on, though, to indicate my own welcome to everyone who is here. We have a number of dignitaries from the Consular Corps, from the Diplomatic Corps. We have Sir Kenneth, I'm looking at to my left, former Governor General. I'm seeing Mr. Bruce Golding, who is a former Prime Minister. I'm seeing members of government, former ministers and so on in the audience as well. Preeminent council and others are here, including from the university community. And we're very happy to have everyone here. And I want you to enjoy the program, to ask as many questions as you want to ask. We will facilitate them. The other thing Mr. Patterson said, in fact, when he called is, I do not wish to be constrained by time. I intend to answer the questions as they are presented. He was very clear, you know, and even this time of day was organized with that in mind, that he did not wish to be constrained by time. So do feel free as you participate, as you listen, as you make your notes with a view to questions, to ask them at the appropriate time, knowing that they will be answered. And hopefully when we all leave here, we will find ourselves in a position where we at least understand a little better some of the things that we may not have known, or get to a better understanding even of those things that we thought we knew. So again, thank you. And at this point, I wish to invite Principal and Pro-Vice Chancellor, Professor Denzel Williams of the Mona campus, to bring his own welcome to everyone to the Mona campus as we are here in the Faculty of Law at UWI. Thank you.
Thank you very much, Mr. Master of Ceremonies, Dr. Malcolm. You have done such an excellent job. I don't know if I need to welcome anyone anymore. But let me use this opportunity to say a big thank you to the Faculty of Law for hosting this very important reasoning session this evening. It's really my distinct pleasure to say welcome to all. I do not wish to get into the business of a protocol list, Dr. Malcolm, because everybody here is distinguished. So what I would say is just welcome to all nice and decent people to the Faculty of Law. It's indeed, ladies and gentlemen, a wise man once said that if fish comes from the bottom of water and tells it's deep, actually believe it. No, Mr. Patterson, I'm not calling you a fish. But what I will say is that Mr. Patterson was at Lancaster House in 1962 as part of the process that actually led to what we now have as our Constitution in Jamaica. And so there's no one more eminently qualified to talk to us about this very important subject matter as we embark on a new process for a reform of the Constitution as we now have it. So Mr. Patterson, we really look forward to hearing your comments and your reasoning and insights on this very important process this afternoon. But this is done in the broader context of what we do here at the UWI. At the UWI, we have what really undergirds our operation, what we call the AAA strategy. And that strategy speaks to a very fundamental tenet of our university, which is alignment. And it calls for our university to take the knowledge that is produced within our walls and bring it to the public to bear on solutions for a better society. And through our alignment pillar, today we are here with our reasoning series, which is really geared towards taking the thought process from our university and bringing that to bear on public discourse. So we are a university that is steeped in public advocacy and thought leadership. And today, this is an example and a manifestation of that advocacy that we're doing. So we're very proud of our Faculty of Law that is not actually carrying the banner of thought leadership and advocacy on our behalf as a university. And so today, I really look forward to the reasoning. I look forward to the insights, but more importantly, what we do is to look forward to whatever outputs that are coming from here that can be used as part of the process to improve our Jamaica land we love. So ladies and gentlemen, welcome again. Thank you for being at our university. And Mr. Patterson, thank you for engaging with our university. I wish you well. Thank you.
Okay, thank you, Principal Williams. And again, it's now for me to do something which is a difficult task for this reason. The program says I'll introduce Mr. Patterson, but I will tell you that I have been specifically told that he does not wish to have much said. And in fact, in words which are much stronger than that, his office told me. So I will simply say, as I was told to do, that Mr. Patterson is here to address us, but I will do a little better. Mr. Patterson is, he holds many distinctions, including having been conferred with the Order of the Nation. He's a Privy Councillor. He's a preeminent attorney. Was a Privy Councillor. He is a preeminent attorney at law and, in fact, is still a King's Counsel. And he has served Jamaica in multiple capacities, including as our longest serving Prime Minister. And he has touched many aspects of our lives and has done so for a very long time. And what he will do, as he ordinarily does, is to take with him his deliberate approach to doing things, and will very deliberately speak to us today about the constitutional journey that we've had in Jamaica from where it began. What we have currently, that is, the 1962 Constitution, coming out of that passed on the 4th of July 1962 Order in Council, and what has happened since. But he will speak to that process. He will give us his own views on it and give us a better understanding of it. And so at this moment, it gives me very great pleasure, as it does, of course, the University of the West Indies, the Faculty of Law in particular, and all of us as a nation, and those broadly beyond who are listening and observing what we're doing, to hear Mr. Patterson present his own words to us and to tell us the context in which the Constitution as we have it was developed, and to look as well at some of the outcomes that we could possibly be looking at as we're contemplating constitutional reform at this time. Mr. Patterson, thank you.
As the oldest alumnus of the University College of the West Indies, I have been given permission to speak from where I sit. Moderator, Pro-Vice Chancellor, Professor Williams, members of the UWI Academia, the Faculty of Law and the Law School, members of the clergy, members of the bar, Your Excellencies, members of the Diplomatic Corps, former Governor General Sir Kenneth Hall, former Prime Minister Mr. Bruce Golding, who I especially welcome because he's one of the few persons who entered Parliament in 1972, still alive today. Distinguished guests as you all are, both those present and online, ladies and gentlemen, I want to thank you for your presence and your willingness to participate as we gather for a reasoning on the Jamaican Constitution. It is my honor, and I felt it was my duty, to share with you such perspectives as time will allow on the background, the origin, the operation, and the future as we seek to indigenize our Constitution, abolish the monarchy, and achieve full sovereignty at last. I begin with the 30th of May, 1960. I was walking on the main street in Morant Bay. We were preparing for a federal by-election because Robert Lightburn had resigned from the federal House to successfully contest the seat in the 1959 election. And Edwin Allen, who had lost in northwestern Clarendon, was supposed to be the candidate for the seat. As I was walking towards the campaign office for which I was responsible, I saw the unmistakable figure of Sir Alexander Bustamante walking towards me with a crowd of about 30 persons or so. I thought it prudent to try and duck behind the wall. But he had spotted me. And when he came to where I was, he said, "Come here, Sonny. I thought you had followed my advice. I told you long ago to be off to London to study the law, to see if you could be even half as good in the law as my cousin Norman. Instead of following my advice, he has you running up and down the country like mad ants." And then he said, you will soon see it will all come to naught." I didn't understand what he meant. But that night, on his return to Kingston, he announced that the Labour Party which he led would be mounting a campaign to leave the Federation. That resulted in a meeting of the cabinet the following day and Norman Manley's decision to announce his intention to hold a referendum. When that referendum was held by a majority of 40,000 persons, the people decided that Jamaica should go on its own. Following that, a resolution of the House, moved by the Premier, established what was a joint committee to prepare proposals for an independent Jamaica. Please remember that by then, Jamaica had attained what was called full self-government in the Constitution of 1959. And even for some matters that were reserved, like external policy, Norman Manley had found a way of getting around it. So, for instance, we had imposed a ban on goods from South Africa, and we had also required visas for persons entering from South Africa. After deliberations, the Joint Committee took the decision that Jamaica would be a constitutional monarchy with a bicameral legislature. And that decision determined the contours and the framework of the draft constitution, and delegations proceeded from two sides to London to conclude the new Jamaican Constitution. I was privileged to have an insider's view of everything that was taking place. In fact, I was required on my way to LSE to stop at the hotel to find what would be going on for the day, and to stop on my way home when they had returned from Lancaster House to learn what had transpired. And when there were receptions and Bustamante and his delegation were present, Buster would say to me, "My cousin gave me hell today." Or, when things went his way, he would say, "My cousin was as brilliant as no one else could be today." The Jamaican Constitution was the first of its kind. And among other things, it created the position of the leader of the opposition and vested that holder with certain specific duties and functions. I think you have to understand the context in which those negotiations were taking place. Norman Manley was the premier. Bustamante had just won the referendum. There was no compulsory requirement for an election to be held, although Bustamante was demanding it. And therefore, both were negotiating a constitution when neither knew who was going to be the prime minister and who would be losing and therefore ending up as leader of the opposition. And that is fundamental to any understanding of how the Constitution was designed. So, they created a Senate, 13-8, regardless of what was the majority in the House of Representatives, and entrenched certain provisions which could only be changed if you got at least one vote from the opposition side in the Senate. The leader of the opposition was also vested with the right to be consulted on certain critical appointments. And I'm going to have to say a word more about what consultations mean and what it doesn't mean. Bustamante was heard to say very soon, "I have to consult, but I don't have to get agreement." And we have to look at what that has resulted in the course of time. There were some issues that had to be resolved in London and, of course, sanctioned by the Colonial Office. But I think it's true to say that the broad provisions in the Constitution were determined by the two parties representative at the talks. Bustamante had a way of saying things in very short, simple, but profound terms. And he announced from the start, "I am with the Queen and for the Queen," full stop. He then left it to his delegation. And of course, Manley, the legal scholar, who was steeped in the doctrine of the greatest authority on the unwritten English Constitution, Professor Dicey, was the one who crafted the provisions of the Constitution that not only entrenched the monarchy deeply, but I should point out that if a referendum is held where there is not a two-thirds majority from the Senate, it can't be changed by a simple majority in the referendum. It has to be done by two-thirds majority in the referendum. And please bear in mind that no political party in its heyday, no matter the sweep, has ever won two-thirds of the vote of the electorate. There was, in accordance with the British practice, a separation of powers. But the difference between the monarchical system and the republican system is that each part is headed by the monarch. So it is the monarch's legislature, the members of the cabinet are Her Majesty's ministers, and the judiciary are Her Majesty's judges. And that is why cases, criminal cases, are brought either Regina versus Adijah Palmer or Rex, as it now is, against Storm Campbell. There were some issues like the prerogative of mercy, which resides in the monarch. In Britain, it is exercised by ministerial advice. After a very long debate, they decided that it would be done by a Privy Council appointed by the Governor General after consultation with the Prime Minister. I must tell you that as Prime Minister, I was very happy about that decision for one simple reason. I didn't want to have to deal with persons who were applying for clemency. Leave it to other persons' hands. One of the big ticket items had to do with the Director of Public Prosecutions. Up to then, it formed part of the Attorney General's department. There were some who wanted to create the office accountable to the Attorney General. There were those who were determined that the DPP should stand alone and be accountable to no one. That point won the day. When you see the age limit that was fixed, believe you me, it had nothing to do with the Pensions Act, because several people who were DPPs went from there to the Court of Appeal. Swaby, Carr, Ian Fort. It came from a very simple view. The aphorism of Lord Acton, power tends to corrupt, and absolute power corrupts absolutely. And since the DPP was accountable to no one, the tenure was determined by an age limit. And if an extension were to be granted, although the appointment is by the Public Service Commission, as is the Auditor General, in that case, it has to be done by the Prime Minister in consultation with the Leader of the Opposition. And I am not making any statement ad personam. I am saying very clearly that the change of that position, which is before the courts and on which I will not comment, runs contrary to the original intent of the position. Another big issue, and we have dealt with that long ago, was when should be Independence Day. Some wanted it on Emancipation Day. Dr. Ivan Lloyd came up with the proposal, first Monday of every August. And you know the processes by which that has been changed. And there was also the question of the valuation and the method of the acquisition of private property, which was subject to judicial review. No entrenched section or deeply entrenched provision can be altered without bipartisan support in our legislature. And fundamental changes cannot be imposed by a simple parliamentary majority. Therefore, real constitutional changes must entail political consensus. Recently, when AJ presented his book, there was a thorough exposition of why we should remove from the Privy Council to the CCJ. But in the context of this presentation, I am forced to indicate why it is essential that we do so to complete our full sovereignty. As a student of the law, I was furious when I went to the Howard Hotel that evening, and I was told that the Privy Council was going to be the final court of appeal. Norman Manley was not known for his patience. He had other virtues. But when I started my protests, he listened to me without interruption. I asked, how could the National Party subscribe to the retention of an apex court that was created to maintain the cause of empire and maintain its dominion through the Privy Council as the final determinant of all legal rights? I asked him, how could you ignore the existence of a brilliant court led by Chief Justice Hallinan, with eminent jurists such as Alan Lewis, Loku, Rennie, which was universally accepted as one that accorded with the highest standards for superior courts based on the common law. And when I was finished, he proceeded to do a demolition job. He said, the Federation is going to be dismantled. The federal court will disappear. We will have, after the independence, to meet with our colleagues and determine how we replace the federal court. And for that reason, and for that reason only, we are putting in the Privy Council as one for simple amendment. We can take it out and put in what replaces it when we have so decided. Argument done. Believe you me, don't sell Bustamante short. If he had wanted the Privy Council to remain the final court of appeal, he would have insisted on its entrenchment. I am equally indignant at a claim that the call for the creation of a Caribbean court as the final appellate body was spawned by either of our political parties and was therefore, at its inception, a partisan issue. It came from Akbar at a meeting on this campus. I can't forget it was a Saturday for reasons which I'll share with you. I made the mistake of leaving my chambers at 11 o'clock without getting my weekly allowance. My secretary gave it to my partner, Tony Spaulding, who, armed with my money, went down to Victoria Pier, as we usually did. And he announced, PJ sends his regrets, but says drinks are on him today. When I went home, I saw Tony Spaulding in my living room, as drunk as a lord, without a cent of my weekly allowance. That meeting of Akbar gave 5 compelling reasons why we must have a court of our own. And to this day, I have not heard any argument advanced by anyone that in any way erodes the legitimacy of those contentions. Now, funnily enough, the first action taken by the government was led by the Right Most Honourable Hugh Shearer, because he took the Akbar recommendation to a meeting of heads in 1970, and they agreed then and there on the federal court. There was a long hiatus, and indeed in the 70s, we were concentrating more on Carifta, moving it to a common market, moving it to a community. It is when we began now to move towards a single market that it became obvious we would have to visit with urgency the question of a tribunal. The meeting in Antigua of heads met in caucus. The Prime Minister then was the Most Honourable Edward Seaga. And I quote, "Caucus decided to avoid the option of a transitional involvement of Caribbean jurists in the Privy Council and take instead immediate steps towards the expeditious establishment of a Caribbean court as the final appellate body for English-speaking countries." End of quote. Ozzie Harding, King's Counsel, was a member of the Regional Attorneys General entrusted with the draft framework. Not one single ground has been advanced why this vestigial colonial institution should remain. What changed? The government. And the then leader of the opposition thought he was going to lure me with the fantasy of an indicative referendum. I was never going to succumb to that temptation. The differences between the two parties were reflected in our election manifestos of 2002. Now, the matter went to the Privy Council eventually, and let me say this. I accept the decision of the Privy Council because it is final, not because it is right. Why do I say this? What we lawyers call the ratio decidendi, meaning the reasons for the decision, are fundamentally flawed and indeed reflect a level of contempt which I find repugnant. Because on an examination, the Privy Council was satisfied of the quality of the composition of the court, its protection by a treaty, but it invoked what I call the doctrine of anticipated malevolence. What do I mean? What do they mean by that? Lest one prime minister would go rogue. And they said, one prime minister can interfere with the Caribbean court, but everybody knows nobody can interfere with us. Within 1 year of their saying so, Tony Blair changed the entire structure of the English judicial system and abolished the House of Lords as the final appellate court and instead constituted the English Supreme Court. I have to say that because I'm often misquoted by saying the law is not a shackle. I never said so. And I am sure the jurisprudence that is taught here allows people to understand that there are different approaches to the law. In my view, and I'm persistent in that, it has to be a tool of social engineering. Apart from my pleasure which is customary in seeing Mr. Bruce Golding here, he can attest to what I am about to say. The CCJ is our court. We fashioned it ourselves. We have paid our share for it. And having regard to the debate in Parliament, we made it an itinerant court so it can sit in Jamaica. It has now passed the 10-year test. One of our most brilliant jurists, Dr. Lloyd Barnett, wrote an assessment of the quality of the judgments issued, which I started to discuss with Mr. Siaga in an attempt to persuade him. But unfortunately, he fell ill before that discussion could be completed. During Mr. Golding's tenure, he commissioned quite understandably a study on whether we should have a final court, which is a Jamaican court, as distinct from the CCJ. And the answers are clear. We simply can't afford it. We're paying for one already. And we will be competing with the CCJ from the same pool of talent. Justice has a cost. And if we can find the money, we should use it to improve and perfect our justice system. That is why we all applaud the new remuneration package for the judiciary. I go further. We must retain the highest levels of competence. We can't afford judges of the Court of Appeal who are just getting in their ring acky where the law is concerned, to be retiring at 70. We should be considering adjusting the age upwards to at least 72, possibly 75. Some cases have come to attention recently. There is a case of Lessine Edwards, where he was acquitted by the Privy Council. But you know why he was acquitted? The Privy Council made resources available for them to do a scientific study which was not available in the court here. And one thing we have to understand, poor people are denied the equality of justice because justice is costly. If Vibes Cartel didn't have the money, his case wouldn't have gone to the Privy Council. But his case should not have gone to the Privy Council if we had in place a system that records judgments of our own Court of Appeal. Because if it had, somebody could have looked on those judgments and found that our Court of Appeal here, Zaka and Rowe, with Rocky White dissenting, had decided that once there is any sign of contamination, you must dismiss the entire jury. I am not oblivious to the fact that right now there's a tide because of the judgment or the way the Adijah Palmer appeal was handled. But please note that the same way the Privy Council streams its hearings live, so does the Caribbean Court of Justice. So, 62 years after our independence, it is more than overdue for Jamaica to depend no longer on an order in council to abolish the monarchy and to vest the judicial arm with the full authority to dispense justice for all as we seek to develop a Caribbean jurisprudence. I repeat, our founding fathers envisaged the establishment of a Caribbean court at the apex. It should remain as a settled national position and not be subverted because of political expediency to be a partisan divide. I move now to the matters pertaining to the reform of other aspects of our Constitution. During the 1978 conversations, the PNP was insistent on an executive president chosen by the electorate. The JLP favored a ceremonial head of state appointed by parliamentary procedures. The Carr Commission, by a majority decision, after extensive debate, recommended, and I quote, that the formal head of state should not be an active politician and head of government, end of quote. It proposed that the head of state should be appointed on the nomination of the Prime Minister in consultation with the leader of the opposition, subject to confirmation by a 2/3 majority of the members of both houses of Parliament sitting in joint session. This, it felt, would invest the selection with an aura of democratic approval, and the Republican form would replace the monarchical in a manner indicative of our national identity and consciousness of our self-esteem as a nation. I sought during my tenure to move forward to completing the structures of our independence. It was my view that the process towards our self-definition as a people had to be accelerated. The institution of our own indigenous president as head of state in the Republic of Jamaica must now be placed on the front burner of the public agenda. In order to obtain a consensus on these new constitutional arrangements, I sought and obtained at our annual party conference in 2001 permission to accept a ceremonial head. And let me say this: our constitutions are based on a figment that political parties do not exist. They do, and they matter. And to operate the constitutions properly, we have to take in account the reality of their existence. We were about to see eye to eye, Mr. Siaga and I then, when my good friend Bruce returned to the fold. And Mr. Siaga said to me at the Vale Royal meeting, Bruce has brought some ideas again about the separation of powers. We have to get some time to sort it out. I did know, Bruce, that already there were some other sleepers in the JLP who were also of that view. The net result of it is that we didn't move forward, and with Mr. Siaga's departure, the only meeting that I had at Vale Royal with the new leader of the opposition, Mr. Bruce Golding, he told me then he had just assumed the leadership. He had set up a committee under Mr. Senator Dwight Nelson, and they needed some time. I say this frankly, I have always worked assiduously to obtain a national consensus. I think it is critical to the future of Jamaica that we do as much as we possibly can together in a united way than as differing political tribes. What I did before departure is to change the oath being taken by prime ministers, because it was very hard and uncomfortable to swear allegiance to a foreign monarch. And when we had the swearing in on the 23rd of October, I moved it to Emancipation Park rather than King's House deliberately, because I was able to swear to be faithful and bear true allegiance to Jamaica, to uphold and defend the Constitution and the laws of Jamaica, to conscientiously and impartially discharge my responsibilities to the people of Jamaica. The issue of citizenship has always been a burning question. The British Commonwealth, as it was in 1962, no longer exists. We are now in the Commonwealth of Nations. Once the monarch goes, so must disappear any concept of a shared common allegiance. We changed in 1993 the constitutional rights to citizenship by descent by making sure that women were placed as mothers on equal footing with men as their fathers. And so some people are not only of Jamaican descent by birth, but also entitled to Jamaican citizenship by their descent of their motherhood. In my view, and this is in the report, which I support, no valid reason exists for maintaining the provisions pertaining to a Commonwealth citizen other than a citizen of Jamaica, who is resident for at least 12 months to be eligible for parliamentary office. The qualifications must be based, in my view, on Jamaican citizenship. I don't want to cause any confusion. Citizens of the Commonwealth are at the present time legally entitled to sit in the House or the Senate. I am deliberately confining my remarks to the constitutionality of any such position. Political considerations are well above my grade in the pavilion. It is my considered view that Section 40 should not be confined to parliamentarians, but extended. In my time, there were 2 appointments I had to make. The people disclosed to me that they held citizenship of another country. I told them, not putting any pressure on you, you have a choice. Renounce and stay where you are. Or, if you want to accept this position, because of its sensitivity, you have to renounce. Both, without hesitation, proceeded to renounce and were duly appointed to their positions. There are some positions that I think have to make it clear that allegiance is to Jamaica alone. For example, the Chief of Staff. Otherwise, you're exposing the person to charges of treason. The Permanent Secretary and members of the Defense Board. I raise, without making any proposal, we have to look at questions of persons like the Chief Justice, like the President of the Court of Appeal, like our electoral commissioners and the Director of Elections. All of these require further national scrutiny and discussion and would apply to further appointments as existing conditions of judges cannot be altered to their disadvantage while serving on the bench. I am not moving into the political arena, but I think I have to ground what I have to say by setting out the base on which our democracy rests. The existence and spread of the 2 major political parties since the grant of universal adult suffrage have ensured smooth transition in accordance with successive election results, and we deserve to applaud ourselves for that. It is commendable, but we cannot ignore how tender and delicate is the plant of the Westminster model, where a first-past-the-post system may still allow a majority of seats, but a minority of popular votes. Lopsided parliamentary majorities often conceal the real margin of the popular will, and the more so when we witness a worrying decline in the number of persons who actually exercise the precious franchise. So, there can be a government in office which in fact does not command the support of a majority within the nation. I believe we should seek in the design of our new constitution to foster a participatory democracy. I would dare to suggest that we can begin with a step that entrenches local government, that gives it a more functional role and greater community involvement in several aspects of rural and urban development as they affect our daily lives. Eradicating political tribalism must be our goal. We have seen what can be achieved whenever we reach a national consensus, and in our own way, fashion and create an institutional machinery to effect it. The Electoral Commission is fitting testimony that we can. It rescued this country from civil war in 1980 and reached a point where, with a 32 to 31 majority, we could see the swearing in of a new Prime Minister without a single shot being fired anywhere. Here I'm going to make a fundamental point. I believe that we have to change the portions of our Constitution which speak about Prime Minister after consultation to Prime Minister with the concurrence. And I speak as one who had to apply the present system for 14 years. And I will say very frankly, admittedly, there are some times when I insisted on having my own way. But in the majority of cases, by a process of communication and interchange, the leader of the opposition and myself were able to reach consensus on critical appointments. And this is where what is called the Vale Royal talks come in. We cannot overemphasize its importance or its potential. And I will share with you, when it comes to things like the Judicial Services Commission, or the Police Services Commission, or the Public Service Commission, if it became necessary, Mr. Siaga and myself would meet in my room at Gordon House, and we would exchange names, and we would finally agree on a list of persons best suited to fulfill the particular functions. This is a lead-in to one of the provisions in this report of the CRC, which quite frankly fills me with great alarm. It is the proposal of a two-tiered system of the election of a president. It is absolutely unacceptable, must be vehemently resisted, and would totally destroy the purpose and intent and legitimacy of a head of state. Because what it is saying is, nominated by the Prime Minister, and after consultation with the leader of the opposition, and if you can't get 2/3, it speaks about taking into account political realities in our democratic system of government. It also provides a solution through the application of the majority rule to a problem where gridlock exists. You cannot afford gridlock in this. There are several things that can be done. You can, in Barbados, it is done by the Prime Minister and the leader of the opposition. If you put that position in, you will not only get 2/3, you will get unanimity. If you don't put that in, and the first nomination fails to get the 2/3, you must treat it like a papal consistory. That is to say, lock them up and don't let them out until you have got a nomination. Then you can let the smoke out of the chimney. We have elected a new head of state. I also have a concern about the proposals for the extension of membership in the Senate. And let me say it very clearly, I am not opposed to a careful consideration as to whether you should get representatives in the Senate other than those which come from the political parties. I am saying that the categories would have to be specifically defined. They would have to provide for the people within that category to do that selection and not vest it in the head of state, because if you vest it in the head of state, you are having then an interference by the head of state in the legislative process, and that you cannot afford. And I'm saying, if you're going that route, consider very carefully whether the representatives of the diaspora should not have some role or some voice. In speaking of I am not proposing it as a settled matter. I am saying if you are going for putting in the church, the private sector, the unions, the NGOs, there is a very important group called the diaspora. So you would have to look at whether or not you are going to include them. And if so, how? Because the oath of allegiance, which those citizens are required to take, make it inconsistent for them to be serving simultaneously in the Jamaican Parliament. And please also note that there are several Jamaicans who have lived, particularly in the United States, for years, had children and grandchildren who to this day operate on green cards because they refuse to take an oath of allegiance which will in any way seem to renounce their Jamaican citizenry. So this matter really needs very careful further consideration. I also am very concerned about the proposal to extend the life of Parliament for new conditions. And the proposal is that could be extended for up to 2 years. I am not for that. If you can have a general election in the middle of a global pandemic, I don't see any reason why there should be an exemption that could permit the life of the legislature and a denial of the people of the right to choose for 2 years in those circumstances. I would also have hoped that having abandoned the proposals in the Carr report to include impeachment proceedings against parliamentarians, the CRC would have proposed the entrenchment of the Integrity Commission. Let me pose the question, where do we go from here? I note in a letter today that it is being suggested that the report should be laid on the table of the House, that there should be room for public ventilation. I would strongly suggest, as we did for the Carr report, that the report should first of all be debated in Parliament, in both houses, that it should be referred to a joint select committee to permit submissions. And then I think there has to be what I call meaningful Vale Royal talks. What I call a come to Jamaica moment. I believe the reformed constitution must seek to capture popular will, symbolize national values, and inspire us as a land of beauty to become a great people where our destiny beckons. Let us realize that our nation needs peace, needs harmony, and needs justice for one Jamaica, land we love.
Thank you, Mr. Patterson, for your presentation. At this time, we're going to be opening the floor for the media and for the persons for questions. And there are some roving microphones that are being passed around, or that are available to be passed around. And I take a quick hand. I see Justice Patrick Brooks, being the President of the Court of Appeal, being the first hand that I saw going off. And so we'll pass the mic to Justice Brooks for his question or comment.
Good afternoon. Thank you, Mr. Patterson. That was an exceptionally enlightening presentation, and I congratulate you on it. My question goes back to the beginning. Several stories circulate about the reason for the Chief Justice of Jamaica not being, as the head of judiciary, but not sitting in the Court of Appeal. Could you enlighten us as to why that exists?
But I'll share with you. At the time Chief Justice McGregor was in place, the then Attorney General was J. Leslie Condell. Not only was he Attorney General, but he was present in London, unlike Chief Justice McGregor. It was an open secret that he had his eyes on the Court of Appeal. Please remember, at that time, the Attorney General was appointed through the Colonial Office. And the Constitution was crafted with that in mind. It was accepted that the Chief Justice would be the head of the judiciary. They used the model of the Court of Appeal in England at the time, where the Master of the Rolls, as he was then called, presided, and fashioned the Court of Appeal along those lines, and indicated that there would be a president of the Court of Appeal, and that the Chief Justice would only be allowed to sit in the Court of Appeal when invited by the President and the court was sitting en banc. I don't know if that satisfies your lordship.
Well, perhaps I'd wanted to raise the same question that Justice Brooks raised, but perhaps you could go a little further. There was an issue between Condell, who was then the Attorney General, the desire on the part of our founding fathers to have their own Attorney General. And there was a trade-off where Condell, I think, ended up as Solicitor General and a new Attorney General was appointed. So I'd like you to ask you to comment on that. And one other thing, can you give us, from your recollection,
I don't remember that arising as an issue, for the reason that it was understood from the start that when the new Constitution came into place, the Attorney General would be a political appointee. And of course, the persons remained in place until the date when the provisions of the Constitution came into effect. So there was no hiatus, as far as I can recall, between the time Condell ceased to be Attorney General and the time he moved to the Court of Appeal as President, and the time when Victor Grant was appointed the first Attorney General by the Prime Minister of Jamaica. That's my recollection.
can you comment on, and Trevor Monroe covers it in his doctoral thesis, what was the role of Leslie Ashnime
Yes.
in the formulation,
Yes.
particularly of property rights.
Yes, very much so. The Joint Select Committee locally included his brother, Sir Neville Ashenheim. Sir Neville Ashenheim was not a member of the delegation that went to London. But there was constant communication between that delegation and the members of the Joint Select Committee who were not in London. The issue about property rights arose in this way. The government of the day wanted to have the right to acquire property for public purposes on fair and equitable terms. Leslie Ashenheim had made very strong representations to the committee that was sitting locally that would be repugnant to prospective investors in Jamaica who would feel that their property could be seized. Let me say, perhaps very plainly, Noel Nethersole was no longer the Minister of Finance. Vernon Arnett had succeeded him. And those who were comfortable with Noel Nethersole were not necessarily comfortable with Vernon Arnett. And the pressure was to put property rights on a footing where the acquisition would be based on market value and justiciable. That is to say, in plain terms, if the government decided to seize or nationalize and place the value which was not regarded as market value, the people would have access to the courts. And that was largely at the representation that had been made by what I would call the Ashenheim group. I think I don't know if you remember, Bruce, but you know, when we were negotiating the EOJ, you were a member of that committee, and we actually reached an agreement on some amendments to Section 18. But those recommendations have never been acted upon, what with the change that took place after the document had been signed, both politically and administratively.
Yes, there are a couple of questions over there. Let's see. Donovan, I see there's a gentleman on this side. And then Donovan more.
Good afternoon, Mr. Patterson. Ricardo Brooks, Nationwide News. You seem to place store on the need for consensus, and you mentioned how important political parties are in the process. And I wondered if you do not fear that in seeking to achieve the noble end of consensus, for example, the proposal to have concurrence, the concurrence of the opposition leader, it ignores our lived reality or political reality as a people?
As I said, consultations should have some meaning. There are instances where different choices arise, and certainly people in government are free to exercise those rights. However, there are cases where issues of principle arise, and you have to ensure that in resolving them, they are not simply brushed aside. Let me share an instance with you. The EOJ and I'm going to say something publicly which I haven't said before. A lot depends on the persons who occupy positions, how they approach the discharge of their functions. I realized when I assumed office the role of the leader of the opposition. The then leader of the opposition perhaps would say about me what I am about to say about him. He is not the easiest person to get on with. Granted that. But I felt a compelling need to find some way of relating to him on critical national issues. Our first meeting at Vale Royal, I would almost say, was a waste of time. Our second meeting was hardly much better. But for me, it was more important to find some way of relating with him than it perhaps was to him with me. So I had to find the way. Now, take the question of the Electoral Commission. Mr. Goling will attest how difficult it was to have crafted the agreement for the EAC in the first instance. But once we did it, we realized that it was a plant that had to be nourished. We came to the position of having the Governor General appoint the chairman and members after consultation with the leader, with the Prime Minister and the leader of the opposition. There was one period when the then Governor General sought to renew the appointment of the commissioners. I supported it, and the leader of the opposition objected to their renewal. In constitutional terms, in that situation, the Governor General could have proceeded. I proceeded to suggest to the Governor General that proceeding would have the consequences of bringing the Electoral Commission into disrepute. And therefore, if necessary, I would withdraw my consent. Well, obviously, the position had to be reconsidered. And eventually, we changed the commission by consent, and that commission was the one that has really made the Electoral Commission the strong, vibrant model that it is. Now, I don't think concurrence is impossible. I think if it has to be, it has to be. I don't want to comment on any recent appointments deliberately. But if good and valid reasons are given, they can't be just tossed aside and say, I have consulted, and therefore I must have my way. So I wouldn't suggest, I'm not suggesting that every office or every position needs to be by concurrence. But I am suggesting that we must find a formula that makes consultation meaningful. Yes, please. Please allow Mr. Golding, because I think...
Vale Royal meetings can be purposeless. If the Vale Royal meetings are just another extension of what goes on in the committee room at Parliament, the important thing has to be at the leadership level, there has to be an understanding, and there has to be some level of trust. Now, you and I have a good relationship. I am privileged to have access to your wine cellar. And you do keep some excellent wines. But when we were sitting across the aisle, when you were about to demit office and I was anxious to grab hold of the office that you were demitting, we didn't have that kind of relationship, we were pretty combative. But I think it's important to understand how critical this is. We were able to enact by a 2/3 majority, which would have required the support of the opposition, the Charter of Rights in 2010. And that has had a significant impact on a number of judgments that our courts have handed down. But that would not have been possible if Portia and I didn't find a way to hold hands and say, listen, let us proceed with this. I raised that point because I in my 50-odd years of exposure to politics, I don't think there have ever been two leaders. You speak about Buster and Norman. There have been two leaders who have been more combative than Michael Manley and Edward Seaga. Eh? I mean, I worked closely with Edward Seaga, and Michael to him was like bad news, right? But in the interest of the country, those two were able to come together in 1979 and say, listen, no, we have to deal with this electoral system. That can't be the subject of political fighting anymore. And we did it, which suggests to me that it can be done. But at some point, after all of the committees have met and all the Vale Royal talks have been held, our leaders have to find a way to sit down, drink a beer, have a glass of wine, talk to each other and say, no, in the interest of the country, let us try and see if we can carve a way to get through this. I mean, that's where we have reached.
I'm grateful to you for raising those two points. We've had our differences. As we've admitted in the past, some good times and some bad times. But at all times, we've been able to communicate the one to the other. Now, the Citizens' Charter, it has a history, and I am very glad you give me an opportunity to share it. The Citizens' Charter, which arose out of a proposal by the leader of the opposition, was accepted and acted upon by me jointly. We reached the point where I got up to move second reading of the bill. And it was at that point he said he couldn't support it. Why? Because it was written in legalese. I had to desist because there's no point continuing when you can't get the 2/3 majority. I am very upset that in holding your hand, the opposition did not insist as a quid pro quo that simultaneously with the passage of the Charter of Rights should go a removal of the Privy Council. Oh, they didn't. No. What? No. Individuals did. Please. Individuals did. They didn't do it collectively. Because if they did it collectively, it couldn't be passed. And why that was important, and not political opportunism. The fundamental rights were charted at a time when the Privy Council was in existence. And when there was a provision in the Constitution that any law preceding the Constitution would remain valid, right? And whenever we amended the law, they said it was a new law to allow them to overrule the decision of the Parliament. Now, you're passing a new Charter of Rights. and you giving a foreign court the right to interpret what those rights are. And I say, simply put, the opposition must be reasonable, but the opposition must also demand that it gets what is best for the country in return for some step forward that is being made to advance the rights of the people. So that's my first point. The second one you raise is even more in favor of what I'm saying. If the two leaders can't agree or can't find a way of talking with each other, they have to find surrogates and authorize them to do the communication between themselves in accordance with the instructions that they are given. And you and I know, the meeting where there is agreement to have the Electoral Advisory Committee would have ended in fisticuffs, but for the preparedness of both leaders committed to electoral reform, to entrust the responsibility of the negotiations and detailed workings to two groups, one led by me, one led by Mr. Shearer, and of which you were a member. And we sat down and we did the work. So if there's such a personality clash between the two leaders, we can't afford that to be to the detriment of the national interest of the country. We must find a way, if we say we love Jamaica, and we do, if we say we want to advance the welfare of our people, and I think we do, then we must find a way of getting it done. So, if we cannot agree, find some way of agreeing on a head of state that commands popular support, then we are not worthy of the sacrifices that our ancestors made in bringing us where we are today. You and I know it's not easy, but it can be done. It must be done. Jamaica demands, needs urgently some symbol that is a source of uniting us. It cannot be a foreign monarch. It has to be one of our own that represents what our people stand for and aspire to be. And I think we can find it. In the scriptures they ask, is there no one in Galilee? I believe there are some in Jamaica. We must insist that our leaders meet and continue to dialogue. And if they can't do it, they find people and authorize them to do it on their behalf.
Good afternoon, former Prime Minister Patterson and Dr. Malcolm. My name is Donovan Walker, and I'm the current president of the Organization of Commonwealth Caribbean Bar Associations.
I know, sir.
Thank you. I just wanted to say two things. former Prime Minister. There's a Zambian saying from a very good friend of mine who's a Zambian lawyer who said this. I can't say it in his language, so I'll just say it in English. Having a good discussion is like having riches. And I thank the University of the West Indies for arranging this reasoning and this discussion. It has been excellent. And I just wanted to bring to the attention of those here today, the former Prime Minister mentioned Akbar's reasons that were so eloquently stated in 1970. In the 70s. And I wanted just to point out that in 2024, at our Akbar general meeting, all 16 bar associations were represented, and the unanimous decision was that those reasons pertaining to why the CCJ should be the final appellate court for the region still attains today. So I just wanted to make that point, that it is not simply history. It is, we agree with those points. And then the final observation I wanted to make was that I'm so very pleased that there are two, what I'm going to say broadly, categories of people who are here with us today. I'm very pleased to see the Minister of Constitutional and Legal Affairs here with us, because the work of her committee is in fact heroic. And the opposition senator who sits on that committee, Donna Scott Motley. So I really I'm very pleased to see Senator Scott Motley and Minister Malahoo Fort here to hear and ingest all that is being said. And as important, and finally, when I was making my way up here, I said, you know, it's very important to have the young folks here with us to hear this. I consider myself young, and Miss Israel young, but even younger. And so I brought two of my legal interns, one who is at the law school and one who is at the law faculty, to hear this discourse. So I want to thank you for it. We need to ingest it, and I think we need to make sure that we do not use constitutional reform as a political football. Thank you.
I want to take note of the presence of the minister who surprisingly, although admitted to the inner bar, has taken an outer seat today. And to remind him that he is a signatory to the report of the Carr Commission when he was representing the University of the West Indies in the task force that had been established in 1991. And I would like to remind him that in that report is a clear statement that of awareness that steps are being taken to bring the Caribbean Court as the final court of appeal, and when that decision has been finalized, the move will then be made accordingly.
Thank you very much. Tracy Robinson from the Faculty of Law. I wanted to join everybody, Mr. Patterson, in saying how important your presence is here. Amongst the many dignitaries are the students of the Faculty of Law, and for them this is a historic moment to be in your presence and to be in dialogue, reasoning with you. I wanted to express two thoughts on this idea of consensus and concurrence, which has been a big theme in the discussions. Ghana in 2001, in a series of historic reforms after CARICOM's engagement, introduced reforms which included meaningful consultation, so a rider to what consultation is, but concurrence in several positions. That year, Desiree Bernard, now deceased, was appointed chancellor. She's the last judicial officer ever appointed Chancellor or Chief Justice, because the Leader of the Opposition and the President have never agreed in over 20 years, creating chronic insecurity of tenure for Guyana's judicial leaders. So my concern is we can't legislate or codify political maturity. And how do we want to think about moving forward, both in terms of textual reforms, but creating a culture which befits us, as you so properly described. My last comment is, you've made several references to Vale Royal, and I wondered if the Republic is to be cited in the consensuses of Vale Royal or in another place you mentioned, Emancipation Park. What's the role of the people in this Republic, or are we consigned to the political actors negotiating and debating in private settings or futures?
Yeah. I think both you and I are aware that the tribal tendencies which we see in Jamaica are perhaps reflected very strongly in ethnic divides in the country, in the republic of which you speak. Because I can't for the life of me see how the incumbent administration could find disfavorable the persons who have occupied with such distinction and such balance the positions they presently do in the judiciary, and yet be unable to obtain the consent of the present opposition. So I think there is more to it than seems to meet the eye. It does not, to my mind, jeopardize or nor should it hinder the need. You can't, every country's progress is going to be stultified if it is just on the basis of one side consistently versus another. Now, you mentioned the question of whether you have the discussions in Emancipation Park. I don't think we can go back to the days of ancient Greece, and the democratic system then, as they called it. And I say as they called it because it excluded women. But I certainly feel that there must be an opportunity for national dialogue, national discourse. Now, the question always is, when do you stop making perfection the enemy of the good. And I think there are some things that can command agreement. I repeat, I think the Privy Council is one of them. I cited the history of it, largely to show most of it was done under an administration which is now insisting on an indicative referendum. There's no legal foundation for it. I hope that when the report has been laid, we're going to find a way of having more public discussions, more public discourse. And I think it will have to be, it will take some time to have it properly organized, but I don't think that the inputs should be confined purely to the political directorate.
Good afternoon. Question to former Prime Minister Patterson. I want to go back to monarchy because in listening to the radio and to questions that come in from callers and even in discussions in my neighborhood, there seems to me to be a misunderstanding of where we stand with monarchy. You have explained part of it because I think many people phoning in tend to think that the system of governance which we have of monarchy was imposed on us by the British. And I think you have confirmed that it was not imposed, but it was something that was selected. The other thing is that many people seem not to understand what our relationship with the British monarchy actually is. And they think that we are still under British rule, taking directives from the British monarchy. And also it relates to the Governor General, because when you talk of ceremonial president, many people are of the view that the Governor General actually does nothing. He simply sits at King's House, and therefore a ceremonial president would be a reflection of the Governor General. Could you please explain what is the actual relationship between Jamaica and the monarchy? Although you have given some explanation. And I wanted to say something about the diaspora, if I may. Because I have a concern about the diaspora and the dual citizenship and being able to sit in the parliament. There was an incident in Guyana a few years ago, that led to an election having to be held in Guyana. And my understanding was that a member of parliament or the Senate had dual citizenship, Commonwealth. I believe, if I'm not mistaken, that the person was from Canada. And they caused a crisis in Guyana and was able to seek refuge in the Canadian High Commission and then be aided to leave the country. So I see that as a problem. And then there is another problem from the other side, where Jamaicans, it came up about Jamaicans retaining a green card for the 50 years living in the US. And I believe that many people who have worked in the diplomatic service in the United States can tell you that this can be a problem, because those people are not able to participate in the political life of the United States because they are not citizens, and as I understand it, citizens cannot vote. Therefore, you cannot lobby on behalf of Jamaica by meeting with your senator or state representative or something like that. So there are two sides to this story of diaspora, dual citizenship, sitting in the parliament, and what this can mean for the country. Thank you very much, and thank you for a very enlightening presentation.
You have raised many questions, and I'm going to try and answer them as briefly as I can. Some countries do not permit dual citizenship. Jamaica presently does, and I think it ought to be maintained. Dual citizenship does not, by itself, provide an entitlement for eligibility to be a parliamentarian. And the proposal from the Carr Commission and the CRC would be that it should be Jamaican citizenry that is the qualification, and I support that. That is why I said earlier on, if you're looking at expanding the Senate, then you have to look at whether that would be the area in which there could be some inclusion of the diaspora, but would you have to make it conditional that the person is a Jamaican citizen only? Those are matters that have to be thought out in much greater detail, and I wasn't seeking to give a definitive answer on that. On the question of this, what we call the ceremonial versus the executive, we have in looking forward to be mindful of our customs and our experiences. As I said, in the 1970s, there were many of us, myself included, who would have favored an executive president. I would say there might come a time in our history when that is the appropriate step to take. But I do not believe that at this time in our history, it is the wise thing to do, for the simple reason that, in essence, you are elevating the Prime Minister to the level of head after an electoral process which has as an essential ingredient an electoral contest, and therefore the outcome of that does not result in unity. It has some divisive element which still remains. Pardon me if I just share with you one anecdote that convinced me totally why the monarchy had to go. Bear with me. When I was Prime Minister, a teacher at Mona Prep had an exercise, asked the students to write if I were Prime Minister for a day. And they wrote essays. And one student wrote the most brilliant essay. And the teacher asked him, what would you like for an award? And he said, to meet the Prime Minister. And I responded to that by saying, bring the whole class to meet with me. We met in what was the banquet hall, now the place where news conferences are held. They all came, asked me all sorts of questions about what does a prime minister do, etc., etc. All very intelligent, very bright. When we had ended it, we were serving some refreshments. And during the course of it, the boy who had won looked at the end to the door. And there was a picture of the Queen, which quite honestly had been there for some time. I hadn't taken any particular notice of it, but it was there. And he said to me, who is she? And I said, before I could say the Queen, the boy who had come second said, is she your wife? And I said, the Queen. And the girl beside him said, what does she do? And one said, why is she there? And I tried to explain that she is the Queen, the head of state of Jamaica. And one person asked, where does she live? Now, it was a barrage of questions which surprised me all the more because the Queen had paid a visit here just 2 years before. But these were children of the age of 9, 10. So then they were, 8 and 7. No. If I had any doubt, which I never did, let me be clear about that. It drove home to me, you cannot have, as the head of state, somebody whose symbol nobody can identify with and who is totally unrelated to the realities of Jamaica. Now, let it be said, and I think Prime Minister Golding would confirm, the Queen, when she was alive, has never interfered with the administration of the government. She is a most charming lady, very surprisingly pleasant when she meets you about, Jamaica, with a particular spot in her heart for Jamaica, largely because she came here 1 year after her coronation when she was very young. And, that Jamaica has been one of the favorite places. So it's not a question of her interference in the administration of government. But the Governor General is her representative, chosen by her. I had an experience when I was signing the first Lome Convention with the European Union, of which Britain was then a member. The minister signing had an exequatur from the monarch, Queen Elizabeth II. I needed an exequatur also from the Queen to be able to sign the Lome Agreement. So did all the prime ministers from the Caribbean at that time. So during the course of time, we have vested in the Governor General, soon to be the head of state, some functions which are no longer ceremonial, like the appointment of the Electoral Advisory Committee, the appointment of the National Commission, the contracts, the ombudsman, and a variety of positions, simply as a repository of the authority, the exercise of the choice, in order to avoid it being politically contentious or divisive. So that is why it seems to me to be critical that in the change from the republic, from the monarchy to a republican form, we do find somebody who is a symbol of that unifying force which we so vitally need. And if we need to spend some time to find such a person, so be it. And there are functions that the person has to do pertaining to the judiciary, etc., which the President of the United States has to do, which the King has to do, which the head of state has to do, because certain things are done by the country through the authority of whoever is the head of state. Now, I am not suggesting that a ceremonial plus head must be there for perpetuity. I'm saying at our time and in our situation, that seems to me the best course for the nation. What happens in 60 years' time with a new generation is for them to decide. But let them know that we have laid down a path which they can pursue to make this country the great country that it can be.
Thank you. And we have a few questions left. I know Mr. Patterson said he would have spoken forever, or could, and he would answer any questions, but we really have to wrap on it. But the minister, Danielle has a question, but she has agreed that the minister will ask hers first. After that, Danielle, we have another question over there. Herbie, you have a question as well. We have that's a list, and we'll take you, and that will close it out. Minister? Just press it onto the turn.
Thank you, Dr. Malcolm. Permit me firstly to commend you, Mona Law, the faculty and the university for convening this very important conversation. And Prime Minister Patterson, also to express my gratitude for the perspectives you have shared, whether in concurrence or dissent on the recommendations. I think you have knowledge that all of us can benefit from. I'm really grateful for the conversations that have generated on this very important work. Before I ask my question, I just wanted to point out that the recommendation in respect of the extension of the life of the Parliament actually is not a recommendation for 2 years. Currently, the 2 years is what is in the Constitution, but only on the ground of Jamaica being at war. And in making the recommendation for other reason of natural disaster, we have actually sought to narrow the time frame. So if you look back on it, and this is without comment on your views, I'm just saying for accuracy in terms of what's in the report, so you may just want to look back on that, because it's not a fresh recommendation for a 2-year extension of the life of the Parliament. That is already in the Constitution. It's merely a matter of the ground on which the extension should take place, but more importantly, it's also a narrowing of it, so you don't go to a 2-year in the first instance. But that aside, it's just in case others are listening and may misunderstand. The other thing is that the report has in fact been laid in the Parliament, though no debate has taken place. But I come now to my question. What are your views on where the civil service should lie? So currently we have an arrangement where appointments to the civil service are appointments made by the de facto head of state, either on recommendation or in consultation, but generally. Over time, we have had instruments of delegation placing appointments in local places. But as we go forward, have you given any thought on where properly the civil service ought to be positioned to ensure that there is no undue politicization of the civil service? So there is a need for political staff. We don't have a framework, a defined framework for that, but you see it taking place through appointments and narrow positions. But I really would be interested in hearing your perspective and the Prime Minister Golding's too on that matter.
Yeah. We began with a position where all public servants were officers of Her Majesty. Over time, we have moved away from that. With the creation of statutory boards, and even more so, public institutions which are incorporated under the company's law as distinct from statute, we have moved to some extent in having significant portions of public employees being employed other than by the head of state. We have created executive agencies during the period with some degree of autonomy. I really see no fundamental reason why we should have drastic changes in those arrangements, though I think perhaps the time has come where we need to do a review of what properly can be done simply by incorporating a company, or as distinct from what has to be governed by a statute. In respect of the public's, of what we call civil servants, I really see no reason why their appointment should not be by the head of state on the recommendations of the Public Services Commission. We might want to look at how the Public Services Commission is constituted, its membership, its powers, and its role. But I don't really, it's a question of, if it's not broke, don't fix it. I think we might need some mending, some patching. I would accept that is something that can properly follow when we have undertaken the 3 fundamental steps, 2 of which are shared by the CRC, the Jamaicanization of the Constitution, the abolition of the monarchy. The concern I have expressed about that has to do with the alternative form of appointment. That simply can't be accepted. If the first nomination doesn't work, second nomination, third nomination, until you get somebody with that 2/3 majority. Better still, get the 2 people to agree and have one nomination.
Just to say that it's at the nomination level, not at the confirmation level, that the issue is first is dealt with. I think you've flipped it around. It's not after a nomination has been made and there is failure to arrive at the confirmation with the supermajority. It's the other way around. It's a failure to have concurrence in the nomination.
That's what I'm saying, and I'm saying you must work until you get somebody that can obtain the 2/3. So no alternative, no fallback position, in other words. That's the difference.
I think we should go a little further, because if I have the majority in both houses, and I know that if we reach a deadlock,
yes,
my majority will prevail.
Yes.
There is no inducement for me to try and arrive at consensus.
Absolutely.
I mean, I will string it out, and when we can't agree, then I have my way.
I must tell you, when I saw the thing about absolute majority, I had to call about 3 people and ask them if my understanding of absolute majority was what it is, because I really, it's obvious. In our system, the government starts with an absolute majority. You start with an absolute majority in the Senate. So if it's an absolute majority, then after you abandon the first option and move to the alternative, you get somebody nominated, elected by majority vote. Nothing could be more divisive and disastrous. And I beg you, Madam Chair Lady, please, we've gotten near enough. We got near enough to agreeing on the head of state and the functions, etc., and the 2/3 majority in both houses. Stop there. Stop there. No alternative.
Good evening, former Prime Minister. Quick question for you, given your experience in as Prime Minister and being present when the Constitution was originally being formed, do you think involving the people at this time in the design or content of the Constitution would improve our level of nationalism and patriotism to Jamaica?
That obviously is most desirable and would be most beneficial. I think, in fairness to the CRC, the time gap between the Carr Commission, when there was a fuller and wider consultation, and the operations of the CRC people, have caused people to forget that what came out of the Carr Commission reflected a much wider level of consultation, and it is on that which the CRC was asked to act. But with a span of 10, 12 years in between, with a new generation, so to speak, both of leadership and of electorate, and with the advent of the social media, we really have to find a way of greater people involvement. And it has to include our educational institutions. If I may say so, when I was a student here and they were forming the federation, we were precocious enough as students to draft our version of federation to send to the leaders. I don't see that kind of activity taking place today. Frankly, when people ask about what does the monarchy do, etc., etc., we need a sense of education that includes understanding who we are, where we come from, how we operate, how we move, what are the differences between us, what I might call the texture of the fabric of our society, what out of many one people really means in terms of an aspiration as distinct from the actuality of the divisions and the separations which we know to exist. So I must say this. I hope the work of the CRC will not just be lost. It's something which I believe we need to work on, we need to ventilate, we need to discuss. And in my letter to the Prime Minister, a lot of people forget that I was the one who wrote the Prime Minister on the 21st of November in 1961, asking that we take the steps to remove from the monarchy by the time of our 60th anniversary. I never got an answer to that. And I said in that letter, what a glorious thing it would be for Jamaica if in one campaign to abolish the monarchy and complete our sovereignty. Orange and green, the flags, the colors, and those who want to be neutral and wear white or black or whatever color they want to wear. If all of us could go out on one crusade for the good, the advancement of Jamaica land we love.
We should really be ending on that note. But I wanted to thank you for this, taking us along this very insightful journey. I had complained to you that the chapter in your book about constitutional reform did not give me sufficient information. And I think you had promised to send me the full chapter, which you have not done so yet. But this presentation has really captured the essence of what was taking place. Now, Prime Minister Golding said that veiled royal talks are purposeless. We had a very purposeful one that led to the completion of the CRC when the opposition members were appointed. And I can tell you, Prime Minister, that if you are present in some of those discussions, you would not be able to distinguish between opposition and government, because we have put at the center of our discourse the nation that we would want to see emerge after this discussion. But let me say this. We are at a point now where that very same issue that prevented the formation of the CRC has resurfaced. And the opposition has made it clear that if the CCJ is not taken into account in what we call phase one, it will go no further. Let me remind you, though, that all our discussions are framed around the 1995 report. And that 1995 report did say that we were to depart from the Privy Council and join a Caribbean Court of Appeal. So it's not that was not discussed then. If we are to have a referendum, we have to have both political parties aligned. We have to go to the electorate with purpose. That does not seem to be present at the moment. Would you suggest or recommend that we initiate the conversation around that process with a veiled royal talk? Would you suggest that it is time for surrogates? And that to me would be challenging because, again, you're going back to both political leaders to agree on that process. But how do you see us really embarking on a referendum if these thorny issues are not addressed? No.
I thought I'd indicated my views on that in my presentation, but let me just respond. First of all, understand, you couldn't have one referendum. You'd have to have referenda. Why do I say this? To change the Constitution, including the clauses that deal with entrenchment, you have to have legally a referendum. That's one. The thing about the Privy Council can't be in there because it's not entrenched. So you have to have what is called an indicative referendum. What are you having an indicative referendum for? To find out whether people want the Privy Council or the CCJ? That question wasn't put to them when the Constitution was being drafted. Our political leaders decided that. Our political leaders must decide. As I said, Minister Malahoo Fort, who is present, chaired the study on the options for a Jamaican court. That report should be made available, so we know why it is that a Jamaica court is a non-starter, and why we must have as the CCJ as the final court. It is our court. We have paid for it. We have people on the court. We have people in the commission that picks the people that serve on the court. It is our court. I was very much involved in the creation of the court. When, for example, there was an argument whether you pay one fee for the original and another fee for the final, I led the attack. One fee, irrespective of whether it's final or appellate, because it's one court. So we paid for it already. So if we have extra money for justice, which I would strongly support Minister Chuck, let's use it to improve the justice system. But don't let us try and restore it. No. My view is the political leadership should meet. There is absolutely no reason. I know of no just cause or impediment why Prime Minister Andrew Holness and the leader of the opposition, Mr. Mark Golding, and their respective teams cannot gather in a suitable facility while Vale Royal is being repaired and get a supply of food and drink and bedding if necessary. If you have to get some rooms in a hotel, so let it be. It's worth it. The country needs it. Duck down in there and don't move until you get agreement. And if you need to call in anybody on the side for little help or back room, there are people at both sides can identify, call in and help. I don't know if I should say this. I will. After the 1916 elections, the morning after, 2016. Pardon me. After the 2016 elections, Mr. Siaga called me and he said to me, the 32-31 results is sending us a signal that the nation is divided in the center, right down the middle. And it is a sign for us. The electorate is sending us a signal. Time to combine and work together as one. And he went on to say, when I think of the missed opportunities on both sides that we have suffered because of the division. I believe this is a sign for us. That's something which I feel about very, very strongly. There must be a way. We have to find it. It's one Jamaica. Little island. 3 million inside, 3 million outside. Come. We show we are capable of greatness. If we, I'm not suggesting that, political contests cease and rivalry and debate be discontinued. That's not what I'm saying. What I'm saying is there are some issues that are compelling. I don't want to get onto the values and attitudes business. But we're destroying ourselves. And in a way, if we keep on like this, no party should be fighting to win elections. What kind of country do we want to take over? So, this is why, Minister, I recoil at the suggestion about the selection of a head, because it is a confession of defeat. And I don't like to lose. And I don't want the nation, Jamaica. I am going. Just a question of when. But I'd like to know that when I go, Jamaica has been able to unite about something that is meaningful, that can make us the great people which we are.
Good evening, ladies and gentlemen. Mr. Patterson, I want to thank you for the discussion and especially the historical contexts in which it's grounded. I'm very much appreciative of that. I want to ask two questions on two issues. One question on an issue that has not necessarily been raised. Is it time for us to consider whether first past the post system is the best system of representation, whether proportional representation, and if not now, when we consider the Senate positions, should we consider for those independent positions third parties that get a certain amount of votes but have not gotten a seat in the lower house?
The second one might have a difficulty in that the Senate essentially is a review body. But you can still find a way of getting some representation of those who were not successful at the polls, if you really look at what I might call a clutch of NGOs. If we're going to be adding to the Senate, I think we have to find a creative way of getting more popular involvement than we presently do under the first past the post system. As to the first past the post system, I've sometimes wondered just wondered, but not concluded, whether there's room for some kind of combination of the system, whereby you have the parliamentary system and allocated to seats to look after constituents. I am very emphatic on that. I believe you must have people who recognize as being among their primary activities looking after the people in their constituency. And I know Prime Minister Golding not only believes that, but even in terms of some of the arrangements about constituency development fund for which he was attacked. Personally, I am in favor that the constituency MPs must have some power, some scope, some authority to do things that affect the welfare in their constituencies. But I don't know if you would have a system of proportional representation. Perhaps that is where some of your ministers could be nominated. Because, and I put it very plainly, very few people can be good ministers and good members of parliament at one and the same time. Some people can do both, but not everybody. So it's something that I would be prepared to consider in future reforms of the constitutional system. What we want to do is to get greater people involvement. That's what we want.
Okay, thank you very much. And we really have had a wonderful afternoon, ran on much longer than we had planned. And the truth is that we could go on even longer. But we sadly have to bring this to an end. And it is for me to, I was planning to do something a little more exhaustive, but I won't. Simply to say, I have had a learning experience like no other this afternoon, and I suspect that most of the others of us have. And the comments I have received as I looked at my phone have included riveting and all sorts of adjectives that I could get into. And the short is that on behalf of everybody here online, including President Saunders and Justice Anderson from the CCJ and others who are online, and everybody here, we want to thank you, Mr. Patterson, for sharing with us an experience that we could not have had other than in this environment. We want to thank, of course, the principal, Denzel Williams, from the University of the West Indies here, Mona campus, for having shared with us and having made this available, and our Dean Ali, who is at the back, for the Faculty of Law as well, for enabling us to have this event in the way it happened. And for everybody, of course, Ms. Hamilton, Debbie Hamilton, she's right there reminding me that I needed to cut the mic. But for all the support she gave from Mr. Patterson's office and everybody over his office, Professor Ramsey, everybody else from that office. And of course, we have from the marketing and communications area, Mr. Odain Murray, Abigail Simpson, Renee McKenzie, and all the team there that pulled the stops out to make this happen. From the Faculty of Law, including beyond the Dean, of course, we have some special persons we must thank. Everybody must have heard some word coming from Mrs. Supersad. She reached out to everybody multiple times. Adisha Coates, Madra Henry, Miss Orr, Mr. Brooks, Mr. Buckner, and the entire team. The MITS team, and Mr. Ishmael Preston in particular, and his IT team. Then there's Jean Leslie and others from other areas. And of course, we can never do this, never ever, without the media and their continuing support. And we know we've been well represented by the media here. And of course, we have the clergy, we have the diplomatic corps, we have a multitude of persons we could go out and thank personally. We just don't have the time to do it all. But thank you again. I see former Dean Jackson, who never moved a muscle as he sat before me. The former Dean as well, Derek McCoy, Attorney General, was here and left. Minister, we thank you for your interventions. As always, you not only support these events, but you intervene. And we're happy to hear your words. So again, thank you all. Have a wonderful rest of the evening. Forgive me for making this as short as I have had to do, but sadly time has taken us to a point where I could do no different. Have a wonderful evening, and we shall meet again. But before I close, please listen to me for 1 minute. Mr. Golden is in the audience, and he will be with us on the 31st of July for a similar event. Mark your diaries.